Assalamu alaikum, Ms. Lutfi, how are you?
I'm
We're
good,
just
thank
waiting
you.
for some of our own or other participants to join as well. So we will just start
Sure,
in like 2 minutes.
sure.
Hello. ठीक है. Um, okay. So once again, good morning, everyone. We'll formally start with today's webinar. My name is Barrister Saki Mangrio, and I'm the Assistant Director Law at the SARC Arbitration Council. It is my privilege to welcome all of you to this important webinar titled Tailoring ADR Solutions, Adapting Frameworks to Meet Industry-Specific Needs in the Maldives. This webinar is being organized by the SARC Arbitration Council in collaboration with the Maldives International Arbitration Center. I want to take this opportunity to express my gratitude to our highly distinguished speaker, Ms. Masha Lutfi, Senior Partner at Alif Law Chambers and a board member at MIAC, for graciously accepting our invite for this webinar, and to all of you who have taken the time to join us. Your participation is what makes this webinar a valuable platform for dialogue and development. The focus of today's webinar, tailoring ADR to industry-specific needs in the Maldives, goes to the core of a small service-driven economy. In Maldives, revenue is mainly generated from tourism, fisheries, maritime logistics, and construction, all of which face different risks and timelines. A one-size-fits-all approach can be slow and costly. Sector-aware mediation and arbitration, better clauses, clearer procedures, and the right experts can resolve disputes faster while protecting relationships and reputation. To get a better understanding, we will look at how ADR is relevant to resort operations and supply chains, how panels with sector expertise, expedited tracks for time-sensitive projects, and digital processes that work across dispersed islands can help this whole area. We will also touch upon all relevant ADR mechanisms and features that help preserve confidentiality and promote enforceability for cross-border contracts so outcomes are trusted at home and abroad. As we begin, I invite all of you to interact with our speaker and to ask relevant questions. Together, we can map quick wins and take next steps that can make ADR in the Maldives more efficient, predictable, and business-friendly, while aligning with regional best practices through SARCO. Here's to an engaging and productive session ahead. Now that we have formally started with this webinar, I'd now like to introduce the current presiding Director General of SARC Arbitration Council, Mr. Shoining Doji. Mr. Doji is a seasoned legal practitioner and has previously served as a member of the National Council in the Kingdom of Bhutan. Additionally, Mr. Doji has also served in the Royal Civil Service Commission of Bhutan, as well as in the Anti-Corruption Commission of Bhutan. Mr. Doji is a fifth Director General, and it has been due to his guidance and support that SARCO has been able to continue its important work of promoting the use of ADR in the SARC region. Please allow me to welcome Mr. Doji to give their welcome remarks.
Good morning, everyone. I think what needed to be said about this webinar has already been said. I will not take much time to repeat all those informations or things which my colleague has already said. Just to brief about this webinar, SARCO has mandate to develop arbitral institution in the member states. Pursuant to this mandate, we are organizing training programs, workshops, seminars, and webinar year after year in every member states. And for this year, today's webinar is the last one in the series. And I can see that the many people are joining us from different parts or locations. I would like to specially welcome our resource speaker, and also I think we have Mr. Rajapaksa joining us from Sri Lanka, and also Judge Rohul Amin, who is our GB member from Bangladesh. Special welcome to three of you. And as my colleague already said, this webinar is supposed to be, intended to be interactive session. I hope our participant engage with the speaker actively, ask questions, share your insight. And finally, I wish all the participants a very encouraging, engaging, fruitful, and collaborative session. Thank you.
Thank you, sir. So, ladies and gentlemen, our main thematic session for today is an overview of ADR laws and frameworks in the Maldives, with a focus on providing tailor-made solutions for specific industries. And to deliver insights on this, we have with us Ms. Masha Lutfi. I'll just take a little bit of your time to just introduce Ms. Lutfi properly. Ms. Lutfi is a distinguished Maldivian legal practitioner of great repute. As mentioned, she is presently serves as a board member of the Maldives International Arbitration Center and a senior partner at Alif Law Chambers, where she advises a broad spectrum of local and foreign clients with a special emphasis on corporate and commercial law. She is also an IMI qualified mediator. Her professional journey commenced in 2012 as a legal officer at the Ministry of Fisheries and Agriculture before joining the Attorney General's office in the same year as Deputy State Attorney. Rising through several posts, she served with distinction as Senior State Counsel until 2019. In addition to her practice, Ms. Lutfi has made significant contributions to academia, having lectured at the Faculty of Sharia and Law, Maldives National University from 2019 to 2022. She continues to practice as a guest lecturer at different forums and as a panelist at various conferences. Academically, Ms. Lutfi holds a Bachelor of Laws honors from Oxford Brookes University and a Master of Laws in International and Commercial Law, specializing in financial services law from the University of Buckingham. Her combination of professional depth, international exposure, and academic engagement makes her eminently suited to deliver profound insights to the audience at this distinguished gathering. SARCO is honored to have Ms. Lutfi as a guest speaker, and I'm looking forward to today's insightful session. Madam, once again, thank you for joining us. And now I would like to invite you to take the floor.
Thank you for the introduction. Good morning, everyone. My name is Masha Lutfi, and it is a pleasure to be with you here today for this webinar on the topic of tailoring ADR solutions, adapting framework to meet industry-specific needs in the Maldives. First, I want to begin by thanking Mr. Choindoji and SARCO for organizing this session and for creating a dedicated space to talk about dispute resolution in a very practical and sector-focused way. For today's session, I have actually prepared a presentation that covers a summary point of what I'll be going through. So I will share the presentation with you all. I hope you all see the.
Yes, madam, we can see you. Thank you.
All right. All right. So now I'm confident that you all have extensive knowledge of alternative dispute resolution tools and their benefits. But I would like to, just for the purpose of today's session, I would like to begin with a quick reminder of why actually ADR matters. So you'll see here that I have highlighted some of the key benefits of ADR that are also particularly relevant in the Maldivian context. First, I would like to highlight the cost effectiveness. We see that court litigation can be slow and expensive, especially for resort, shipping, and construction disputes, which are often technically complex and document heavy. In contrast, a well-designed arbitration or mediation process can significantly reduce both time and legal costs, especially if we focus procedures and specialized neutrals who understand the sector. Secondly, I'll focus on the time-saving benefit. We see that in sectors, especially like tourism and construction, time actually is money. Delayed resolution can mean interrupted resort operations, stalled construction projects, or even detained cargo. ADR mechanisms are designed to reach a result in months rather than years, which is critical for industries that operate on timelines and seasonal cycles. From my experience as a practicing lawyer, a typical dispute in civil court takes an average of 1 to 2 years to conclude. If we exhaust all appeal processes, including High Court and Supreme Court, the earliest a final and binding judgment can be secured through litigation is roughly around 4 to 5 years. But please do note that this is on fast track that does not involve significant delays. While this timeline may compare favorable to some neighboring countries, it is not still ideal within the Maldivian context, especially since this figure does not account for extensive delays, as I have mentioned earlier, that can be caused by prolonged issues and court backlog. Now, I want to share a summary of Civil Court's 2024 case statistics, which I took from their website, to give you an idea of how long actually litigation in first instance courts takes place in the Maldives. So if you look into the chart that I have shared, you will see that in 2024, this includes the civil court, including the Hurumale division of the civil court. They registered 5,142 cases, of which included 515 cases with no disputes, meaning they only require a judicial decision to grant legal effect of recognition. From in the year 2024, we see that a total of 5,432 cases were decided, with 621 of those cases being cases classified as cases with no disputes. This indicates that 106 non-disputed cases were carried over from previous years, taking more than 1 year to conclude. So cases without disputes, which should typically be resolved quickly, as are processed through the same system as complex disputed matters. This results in these types of cases being subject to the same backlog and procedural delays despite their simple nature. We also see that when the year ended, there were 4,759 pending cases, and among them 2,310 cases were carried forward from the years before 2024. So in contrast to these, we see that arbitration cases administered by Maldives International Arbitration Center generally issues awards within 1 year. So we see that there are cases, a huge backlog that takes more than 1 year in practice. Thirdly, I want to talk about confidentiality. We have observed that many disputes across tourism, fisheries, and also our maritime sector involve sensitive commercial information such as contract prices, financing terms, trade secrets, and supply contracts. Companies are often reluctant to share the information disclosed in and disclose this information in open courts. So alternative ADR mechanisms, particularly arbitration and mediation, offers a valuable mechanism for parties to resolve these disputes while ensuring that these confidential details remain out of public record. As a final benefit for today, I will highlight on preservation of relationships. We see that litigation often adversarial and can damage long-term relationships, whether it is between a resort and a tour operator, a bank and its customer, or a contractor and an employer. Mediation and other consensual process helps parties find solutions without burning the bridges. This is especially important in a small jurisdiction like the Maldives, where commercial actors interact repeatedly and reputation also travel quickly. So if we put this together, ADR offers us a way to resolve disputes more efficiently, more discreetly, and with less collateral damage to ongoing business. Now the question is, how do we connect these benefits more directly to our specific industries? To answer that, I will first discuss some of the ADR mechanisms that we already have in place. So I have highlighted a few mechanisms that we have seen over the years. First, I will highlight about mediation. We do not have a standalone mediation act in place yet, but Maldives International Arbitration Center has developed a mediation bill, drafted a mediation bill, which is expected to be submitted to the Attorney General's office soon. Even though we do not have a mediation act yet, the Supreme Court of the Maldives has consistently promoted judicial mediation to expedite case resolution. So, for example, in 2015, a dispute resolution division was established at the Civil Court under a Supreme Court circular. This division, however, was dissolved in 2022 due to jurisdictional overlaps under the Judicature Act. Even though the division was abolished, mediation was proven to be effective. According to the statistics, 62% of the cases that underwent mediation at the civil court was successfully resolved without the need for litigation. This high rate demonstrates the efficacy of mediation in case resolution while indicating the need for formal mediation law in the Maldives. The key stakeholders still, including judges, lawyers, and policymakers, keep stressing the efficiency and importance of judicial mediation. But unfortunately, mediation is currently limited primarily to family disputes handled by family court. So that sums up about mediation. Moving on to conciliation, this is not actually widely recognized as an official ADR mechanism. So conciliation is frequently utilized in private civil disputes to resolve issues while preserving relationship. This mechanism is often employed in matters concerning employees, family issues, commercial disputes within families, and as well as community affairs. Looking into our history, before the establishment of the modern judiciary, the island chiefs played a significant role as mediators in maintaining community harmony. Their authority at the time was rooted in custom and local governance, allowing them to summon disputing parties, hear their arguments, and suggest solutions for disagreements. And these agreements range from family disputes to property issues. So, not falling into the traditional conciliation definition, I also want to note that we also have a labor relations authority that is established under the Employment Act with the mandate to observe compliance with the Act. The LRA has the power to gather employment-related information and documents. And following their own inspection, LRA has authority to issue orders of compliance and also is vested with the power to fine or blacklist non-compliant employers. Moving on to adjudication boards, again, this is not there is no standalone governing law for arbitration boards or committees as well in the Maldives yet. But many government, many government development agreements, particularly in construction, are based on the FIDIC framework. Government authorities such as Ministry of Finance establish adjudication committees. These are actually internal adjudication committees to handle disputes that arise under specific agreements. Now, talking about arbitration, arbitration is now well established under the Maldives Arbitration Act, and it provides the legislative backbone for arbitration in the country. And this legislation is based on the ancestral model law. The Act also established Maldives International Arbitration Center as the primary arbitral institution. And also, Maldives is now a signatory to the New York Convention, which enables international enforceability of awards. In this forum, I want to note that a recent MIAC award was successfully enforced by a Dubai court. And this enforcement is a significant milestone for Maldivian arbitration, demonstrating that our awards carry international weight today. And with this recognition and enforcement, we can see that Maldives arbitration framework has comfortably positioned the country as a credible venue for resolving cross-border commercial disputes, particularly in sectors like tourism, infrastructure, and also foreign investments. Now I want to talk about some tribunals that has been established under Maldivian law. There's one for employment disputes and one for tax-related disputes that arise between taxpayers and Maldives Inland Revenue Authority, MIRA. These bodies act as the court of first instance for such civil matters. Now, most of these tribunals are often structured with strict procedures similar to something we see in the civil procedure courts, making them less flexible than arbitral tribunals. So for these reasons, we are generally classifying these tribunals as quasi-judicial bodies. Since we looked into the statistics of the civil court, I think I also want to share statistics of the tribunals as well. So when we look into the statistics of
Sorry, apologies for that. I think someone was unmuted.
all right, I thought our question was posed, that's why. So I'll continue. So looking into the annual reports of 2024 published by the employment by the tribunals, I will first look into tax appeal tribunal. So according to the statistics, you will see that tax appeal tribunal in year 2024, 13 cases were registered and only 7 cases were closed. So when the year ended, there were 48 pending cases. And among these pending cases, the 13 cases that were registered this year were also included in these 48 pending cases. And 42 cases were carried over from previous years. Looking into employment tribunal statistics, we see that 277 cases were registered this in 2024 and 153 work cases were concluded. The year ended with 244 cases pending. So we see that actually these tribunals are established to expedite decisions on these specific matters, but the resulting question is whether they are operating fast enough for today's mediation society, Maldivian society. A definite answer is not straightforward, and it is complex since some of these delays are caused or attributed by lawyers as well. So I believe they have their own challenges as well in regard to why it takes more than 1 year to close a case as well. Maybe it's, I think, for another forum to discuss their challenges. So for the purpose of today's case, we see that in practice, we still in Maldives, many disputes in the Maldives still go directly to courts or tribunals without parties fully exploring other ADR mechanisms. The contract-based ADR still remains unpopular, with parties often opting for litigation still. But I think by thinking sector by sector, we can design dispute resolution pathways. Now, I have used this term pathways because I believe one type of ADR mechanism will not fit all disputes within a specific sector. Since arbitration is the only currently regulated ADR mechanism, I will focus ADR solutions on issues specific to the main Maldivian industries: tourism, fisheries, construction, and maritime trade. For each industry, I will highlight the common disputes and the mechanisms we can adopt to meet their specific needs. So the main point of focusing this way on issue specific is that while we have many existing ADR tools, as I have highlighted before, what is often missing in the international design is like choosing the right mechanism in the right consequence and tailoring it to the commercial and technical realities of the sector. So I will first look into the tourism sector. Tourism, as you all know, is the backbone of the Maldivian economy. It is also a sector where disputes are multi-layered as well. Current mechanisms, employment resolution mechanisms often lead to a confrontational environment. We see that sometimes the parties are asked to answer, there is a complaint against the employer, how are you going to respond or submit your defenses? So employees are frequently left feeling uncomfortable due to the cautionary notices that are forwarded by the authorities where the employer fails to comply with their request for cooperation or summons. And this ultimately hinders the voluntary resolution from the employer's part. So for this, I think if we start with mandatory mediation or a structured mediation to prioritize dialogue and preserve the working relationships while focusing on resolution rather than portraying an impression of fault-finding investigation, we can find or resolve disputes much faster. And the employers would not be so reluctant on finding an amicable solution. So mediation should prioritize dialogue over confrontation and resolution over escalation. Of course, if mediation fails, the matter can always proceed to the employment tribunal for formal determination. We also see that some disputes arise between vendors and suppliers, which can involve complex issues like payment delays, logistics, and maintenance. Where ongoing relationship matters, contracts should include a mediation clause as the mandatory first step for such disputes as well. If mediation fails, the dispute can escalate to arbitration, seated in Maldives, preferably under MIC rules or other agreed upon rules. This provides a clear pathway with predictable and enforceable outcome for all the parties. But the current challenge we are facing with mediation is the lack of a regulatory framework for enforcing mediation outcomes or converting them into consent judgments. So today what we see is entering into settlement agreements as the closest available alternative mechanisms for such disputes. We also have in tourism sector taxable disputes. These kinds of disputes usually includes disagreements over tourism tax or assessments made by MIRA. The initial forum, as I have mentioned earlier, for such disputes is our tax appeal tribunal. Now, there are a few cases in litigation that I want to highlight where taxpayers are objecting on the ground that a further thorough assessment from MIRA would show that the taxpayers are not liable for the tax that is being claimed by MIRA. So at a hearing, at a Supreme Court hearing, a taxpayer strongly claimed that there was a typing error, which is actually the root cause of a high tax liability, and for that fact requests from MIRA to review the statements. But to which MIRA insists that there is no error and they can't review because of the strict regulatory time limitations. Now, at this point, I also want to highlight that I myself have a case that is ongoing in the High Court of the Maldives, where the taxpayer maintains that MIRA cannot legally establish a tax liability on the taxpayer without first assessing all relevant financial statements involving the transaction in question. So looking into the nature of such disputes, which is actually often involved in technical disagreements over underlying documentations, a neutral third party with relevant expertise could be engaged to assess the matter before proceeding to litigation or tax appeal tribunal. The current procedure is that MIRA is itself reviewing tax objections that are raised by taxpayers to a notice of tax assessment that is done by MIRA in the first place. So under the current tax legal framework, there is limited scope for discussion, mediation, or conciliation. But still, I believe that MIRA can accommodate through its ruling such a mechanism to allow for objective review and facilitated discussions to confirm tax liabilities, payment plans, or partial settlements, while at the same time maintaining the statutory time limitations. This alternative approach, I believe, is crucial because our tax laws rooted in the Constitution prevents any collection of tax that is not in accordance with the law. Because a taxpayer is made liable for potentially millions of rupiah through a strict application of legal procedure and statutory time limitations. I believe a more flexible in-between mechanism is needed for confirmation in these kinds of dispute. So a protracted tax dispute negatively impacts cash flow for both MIRA and the taxpayer. So the case I referenced earlier, that the case I am handling at the High Court, stems from the year 2019 and it is still in High Court. And we still have one other final layer of appeal, the Supreme Court as well. So during this 6 years period, the taxpayer is currently facing legal consequences due to the taxpayer being classified as having unpaid fines or unpaid tax to MIRA. So I think an in-between, as I mentioned, an in-between expert involvement, a neutral party involvement can expedite and resolve these kinds of disputes before it escalates to tax appeal tribunal. I also want to highlight that we also have disputes following lease and investment conflicts. It is crucial or critical to draft robust arbitration clauses from the outset, specifying the seat, rules, language, and qualification of arbitrators, so that early neutral evaluation of first-track procedures can be considered at this stage to expedite dispute resolution. To give a very simple illustration, for example, imagine a foreign investor in a resort project who has a dispute with a local partner over development milestones and revenue sharing. So if the lease and joint venture agreements have clear escalation clauses like first negotiation, then mediation, then MIAC administered arbitration, both sides will know the pathway in advance. This reduces uncertainty and reassures financiers and ultimately suppliers with confidence in this sector as well. Now, I am opting or suggesting Maldives MIAC as the seat because it is beneficial in these disputes as the site of dispute is local and most often times the parties will also have a legal footing here in Maldives. So ultimately reducing time and travel costs associated with foreign seats. So I also want to highlight that MIAC also offers a diverse panel of international experts and as arbitrators, which the parties can choose from. So in tourism sector, tailoring ADR really means aligning mechanisms with the diversity of disputes, employment suppliers, tax, and long-term investments, instead of treating all of these disputes as the same. So here I am suggesting that rather than jumping directly to arbitration or litigation, we can draft a mechanism where it has escalation ADR options. We can start, depending, however, on the complexity and nature of the case, negotiation that can lead all the way to arbitration. Now, looking into the next industry, fisheries. The fisheries sector is another pillar of our economy and it has its own distinct dispute patterns. Under the fisheries industry, I will address three main types of disputes that we oftentimes see. So these are territorial conflicts, where disagreements occur over fishing zones and on access rights, including unauthorized access by foreign vessels. We also have vendor and supplier disputes where conflicts can arise over prices, delivery schedules such as goods or vessels, quality of the catch, and payment terms across the value chain. We also see labor disputes as well in the fisheries industry as well. So labor disputes such as issues related to crews, wages, working condition, termination, and even sometimes exploitation of illegal immigrants. So for territorial conflicts, especially where foreign vessels or cross-border issues are involved, I believe that a bilateral or regional conciliation can be useful. The idea is to have a specialist mediator or conciliator who has knowledge of maritime boundaries and fisheries law, who can help de-escalate disputes before they become political or diplomatic crises. Looking into vendor and supplier disputes, since the goods under this industry falls mainly into two categories, like perishable and non-perishable goods, I will look into them separately. For disputes concerning fresh products, conciliation using technical experts with quick timeline is essential, as the products could lose value rapidly. For non-perishable goods, however, for items like canned fish, contractual clauses could mandate mediation within a set number of days, followed by expedited arbitration if the dispute is unresolved. For cross-border contracts, an online ADR mechanism could also be convenient in such disputes. I have recently noted that some cross-border agreements involving Maldivian companies specify three arbitrator panel and the seat in Singapore. So when I saw these clauses, I asked my client whether it could be or it would be financially feasible to resolve disputes over a few tons of fish or small unpaid invoices through such a high cost complex procedure, such as opting for Singapore International Arbitration. So we see from situations like this that sometimes we simply draft dispute resolution clauses by borrowing from attractive documents without actually considering how much we might have to incur to resolve a simple dispute arising under the agreement. So we should prioritize ADR mechanisms that are scalable based on value and complexity of the dispute. Looking into labor disputes, I would suggest combining mediation or conciliation with existing statutory mechanisms such as employment tribunal can resolve disputes at a faster speed. This model, similar to what I have mentioned under the tourism industry sector, ensures early resolution while also preserving workers' rights and providing a formal safety net if the initial mediation fails. So we see that these tailored approaches ensure that ADR respects both local community, both in local community context as well as in the international dimension of fishing rights. Looking into the next industry, the construction industry, this is one sector where ADR is globally well developed and at the have tools that are very relevant for us and useful as well. When we look into the construction industry, the disputes we face appears to be common to that of our international parties as well. So but still at the same time, I will look into how we can adapt these frameworks in the Maldives context. First, I will look into the frequently encountered key disputes that we face in the construction industry. This involves project delays and liquidated damages, quality and defect disputes, payment and cost overruns, and regulatory and licensing issues as well. So payments and variation claims such as disagreements over scope changes, valuation of variations, and unpaid invoices still stem under this sector. Project delay and liquidated damages conflicts arise in situations where disputes regarding responsibility for delays and application of contractual delay penalties arise. We also have faced sometimes allegations that works fail to meet agreed specifications or standards, including latent defects. These disputes are often technical, multi-party, and can severely impact project completion and financing. So to address these challenges, implementing a tailored ADR clauses could be highly beneficial. For example, project delay and liquidated damages, disputes about who is responsible for delays and whether contractual delay penalties apply. Quality and defect disputes, allegations that works do not meet agreed specification or standards, including latent defects that appears after completion can be covered as well. So for payment and variation claims, we can have early mandatory mediation to resolve disagreements in these types of disputes before they escalate into major project disputes. This approach significantly aids cash flow and also helps the parties to keep working towards progress. I think for construction, dispute spots and expert involvement could also facilitate the projects to go on until completion. In many high-value and government projects that are based on FIDIC framework, the appointed engineer is often unable to resolve disputes between the contractor and the employer in a timely manner. This causes significant delays and protracted disputes. To tailor a solution for the Maldives, an early appointment of an independent government licensed delay experts could avoid deadlocks between the parties. Instead of waiting until arbitration commences, an early assessment report from an expert, such as delay expert, could resolve disputes and help resume halted projects. So the detailed findings of an independent expert as such could be reviewed and advised by legal counsels of the parties, and this can help the parties to resolve the technical issues much sooner, even before resorting to arbitration or litigation. Another effective tool for large projects could be a stand-in dispute board or independent adjudication board. This form of neutral body appointed at the start of a project could visit the site periodically and provide informal opinions on formal decisions for issues that the parties face from time to time. This will allow for dispute resolution in real time, preventing the prolonged delays that are associated with appointing a board after a dispute has fully materialized. For issues involving permits, approvals, zoning, and compliance with regulation, a conciliation process with relevant authorities can help parties find compliance solutions that allow projects to move forward, at the same time offering an alternative to immediate litigation or political pressure. And of course, for complex technical disputes and those unresolved by other means, arbitration can remain as the final step and the last resort. Arbitration clauses can be tailored to appoint arbitrators with construction expertise, or panels can include engineers and quantity surveyors. Procedures can be customized to focus on critical issues with options for agreed document-only phase for smaller claims. This can avoid future disputes over arbitration process itself. So we see that we can tailor different ADR mechanisms for different construction disputes that we face as well. Now, looking into the last industry that I'll be talking about today, the maritime trade sector. This This sector links Maldives to the global economy through imports, exports, transshipments, and logistics. Disputes here can quickly become cross-border and involve multiple legal systems. In the maritime trade sector, we commonly see disputes over spoiled, missing, or damaged cargo during loading, transit, or unloading. Issues arising from port charges, delays in clearance, documentation errors, or alleged non-compliance with custom rules we see oftentimes under port and custom disputes. We also see conflicts over penalties for regulatory breaches, demurrage, or other charges that are contested or unpaid by the parties. For these issues, looking into tailor-made approaches specifically for these outcomes, I would suggest international, for example, for cargo damage and loss, international arbitration could be often a preferred mechanism. Maldives International Arbitration Center or other arbitral institution can facilitate to form specialized maritime arbitration panels with arbitrators who are experienced in shipping, billing of lading, and marine insurance. Arbitral institutions can make available easy search engines that can allow parties to filter their own registered arbitrators based on specific expertise in maritime trade. This can enable the parties to choose a technically competent decision maker, especially for their dispute. So before opting for arbitration, the parties can exhaust expedited online ADR mechanisms as well. For disputes over port charges, clearance delays, or documentation errors, an expedited conciliation process could prevent disruption to trade flows and expedite the dispute resolution. This is a modified fast-track approach where a senior expert helps the port operator, customs, and commercial parties to find a solution with the aim of resolving the dispute on the same day so that the parties can avoid fines or demurrage. The focus here should be on finding a mutually agreeable solution while at the same time respecting the legitimate regulatory concerns of the customs as well. Mediation can also be an effective tool for resolving disputes over unpaid fines or contested demurrage charges. If direct negotiation fails, mediation can help parties to reach an agreement on payment plans or partial waivers, balancing regulatory objectives with that of the commercial realities faced by ship owners or importers. So when we reach here, we have now observed a variety of complex issues across different key industries in the Maldives. Attempting to resolve all this through a single one-size-fits-all court or tribunal process leads to inevitable delays, high costs, and strained relationships. To address this, we must pivot from a pro-litigation mindset towards prioritizing ADR mechanisms before resorting to litigation. This requires us to change the traditional belief that litigation is the only legitimate dispute resolution mechanism available in Maldives. Implementing this shift is a long-term process that will require significant time, expertise, and of course, the willpower to change. So I have summarized here strategic recommendations that we can adopt to make Maldives a pro-ADR platform. So here we see that I have divided strategic recommendations into four sectors: institutional developments, capacity building, awareness and accessibility, and legislative frameworks. So first I'll start with the legislative framework. So I have mentioned earlier that we already have a solid arbitration act, but still there is room to develop sector-specific guidelines or model clauses on issue-based. We already have a model clause that we have published in our MISC website, but it is not tailor-made for specific industry. It is to be used in general in all forms of disputes. So developing a pathway of escalation where arbitration is the last resort before exhausting at least one other mandatory ADR mechanism could help expedite dispute resolutions before resorting to more complex and lengthy ADR solutions, other ADR solutions, or even litigation. We also need to enact standalone legislations to govern mediation and conciliation. This ensures that all these ADR bodies operate under clear statutory mandates with transparent procedures and oversight mechanisms, safeguarding consistency, enforceability, and public trust. Learning from past experiences, we also must ensure that these legislative frameworks have policy coherent and statutory authority when forming ADR mechanisms. So to give an example, past example, we had a settlement committee that was formed in 2022 under a presidential guideline with the aim to expedite a resolution of disputes between the government and private entities, but it was dissolved in 2023 due to lack of statutory authority and constitutional oversight. I have also mentioned earlier that we had a dispute resolution division in the civil court, which was later abolished due to jurisdictional overlap. So these episodes remind us that the need for legally anchored frameworks where every ADR initiative is backed by enabling legislations and institutional accountability when designing ADR pathways. Looking into institutional developments, relevant regulators should create or endorse specialized panels of mediators and arbitrators and develop standard procedures and rules that are tailored to the needs of specific sectors. This includes establishing fast-track rules for issues like perishable goods and specialized adjudication procedures for construction disputes. Furthermore, institutions should play a proactive role to train and accredit ADR professionals, including industry-specific experts. Institutions should establish specialized sectoral ADR panels focused on key industries such as tourism, fisheries, infrastructure, and maritime trade. These panels should be staffed by experts who possess a deep understanding of the unique nuance of each of these industries. Given the geographical dispersion of Maldives, leveraging technology is crucial. Institutions should create secure and accessible digital ADR platforms for online dispute resolutions. These platforms are vital for serving remote islands and engaging international stakeholders as well. So recognizing ADR's potential is a powerful tool for access to justice. Public financial assistance would help institutions maximize their operations and achieve long-term financial independence. So as I mentioned earlier, the only ADR mechanism that is currently established is Arbitration Center or MISC. So through my today's session, I have highlighted that there is a need to establish centers or institutions for mediation or reconciliation. So we are talking about starting from groundwork, establishing these centers or institutions. So that means these institutions will need the assistance of, especially financial assistance of the government to fully come to their operations, and until they can financially be dependent on their own. Looking into capacity building, trainings should target not only lawyers and arbitrators, but could include broad range of industry participants. Key groups could include resort managers, project engineers, fisheries cooperatives, port officials, and other relevant technical personnel. Also, cross-border learning and collaboration with other jurisdictions in the region would be highly beneficial. This approach will allow us to adopt best practices and adapt them effectively to our local context. Now, when we talk about awareness and accessibility, many businesses and individuals still perceive ADR as a distant or overly complex mechanism. To address this, we should focus on increasing awareness through more campaigns, conferences, and seminars in the Maldives. ADR should be a mandatory topic in all professional forums, including financial and human resource conferences, as disputes inevitably follows all these forms of business dealings, necessitating knowledge of resolution mechanisms. ADR needs to be transformed into common sense knowledge rather than remaining a technical topic known only for experts. It must be seen as an accessible first choice for dispute resolution. To ensure practical and affordable access to ADR across the country, a community-based ADR centers could also be established. So in conclusion, I would say that given the unique intersection of geography, culture, and commerce in the Maldives, it is essential that our approach to ADR be tailored, not just to sectors, but directly to the people. So with that, I conclude my submission and thank you all for your attention. Thank you.
Thank you very much, Ms. Lutfi. Thank you for the very comprehensive overview of the relevant sectors of Maldivian economy. I really appreciate how you went through the three main sectors: tourism, fisheries, and construction. We'll now open the floor for question and answers. But just before anyone else asks, I'll ask one question which I've had while looking at your presentation. So during the fisheries section, you mentioned that there are division of two kinds of goods, the perishable and the non-perishables. In the case of perishables, for example, are there any mechanisms in place for emergency interim reliefs? Because perishable items we know that may last not more than 2 to 3 days if it's like fresh goods. So are there any emergency relief mechanisms in place to protect such issues?
Thank you for the question. So when looking into ADR mechanisms, as I mentioned earlier, we do not have a framework, but looking into custom rules, for example, when importing, for example, like let's say for example oranges, and there is a dispute in regard to documentation, or there is a backlog, or some regulations are not followed. So because these can be perishable goods and it needs to be circulated, or it will be when the time these disputes resolved, these goods will be perished. They have mechanisms where these goods can be custom cleared while pending the disputes. They have their internal procedures. But if you look into legal framework, specific ADR mechanisms, we do not have. But customs, they have their own internal regulations for that.
Thank you. We'll just go to the chat section. So which expedited procedures and emergency relief tools best protect time critical construction projects? So similar to my question, but talks about the construction projects instead. So, Madam, would you like to add anything, or should we consider the answer that you gave sufficient for this?
Sorry, was the question posed?
So in the chat section, if you open, so which procedures best protect time critical construction projects?
Looking into the solutions that I have gone through for construction projects, I would say that a standing by committees where they are involved from the beginning can resolve disputes in real time, because the most common disputes that we see in the construction industry is delay in project completion as well as delayed payments. So these are actually connected with each other. When there's a dispute in regard to delay in payment, the whole project gets delayed, and at the end of the day, there's a dispute as what actually caused the delay. So in Maldives, we don't see very commonly the use of delay experts, but it is actually very commonly used in Europe. I see even in international arbitration forums. So I think that is something that we can adopt into our framework uh, when we adopt in ADR solutions for construction industry.
Okay. Thank you, Ms. Lutfi. So another question, in light of challenges highlighted, what would be the best way to design capacity building initiatives? So I understand that you already mentioned that there should be specific training programs, for example, to include resort managers as well. But in what other manner would you also recommend that what kind of specific capacity training programs could be implemented in Maldives?
So as I have mentioned, we have engineers, and under the FIDI frameworks, independent engineers are appointed to oversee from employer side as well. But we rarely see delay experts, for example. But if we can train them in that way, where the community, even litigation or tribunals, can give enforcement and recognition to these experts' reports that can be taken as a standalone expert opinion to decide on who has caused the delay at the step. So even before we can before going to arbitration, at the point of this arisal of disputes, if we can make use of these experts, then we can advise our clients as to how the outcome would be if the case is to proceed to litigation. So one way is, for example, engineering legal experts, resort, for example. What I see is oftentimes, as I mentioned earlier, senior management, most of them is not well aware of alternative dispute resolutions. So for years and years, we have been pro litigation. Our mindset is that the only option, only legally recognized option to resolve disputes is litigation, going to the courts, and other means are just formal discussion way. So if we can train them through awareness and technical expertise groups, then we can actually incorporate alternative dispute resolution mechanisms into the contract. And from my experience, the lawyers can suggest, but at the end of the day, it is the management of the companies that will decide what form of dispute resolution they would opt for. And as I have mentioned recently, I have come across a contract that included Singapore International Arbitration as a dispute resolution with 3-member panel. So as I have said, I asked them, would this be financially feasible for them if they are to go to a Singapore arbitration to claim for an unpaid invoice that involves a few $100s, because they are going to spend a lot of money on a 3-panel arbitration. So awareness is also a key area. And on top of that, I want to highlight that we now in Maldives have specific conferences, like for example financial conference, banking conference, HR conferences, and we see that all these areas, every dealing of humans, there is dispute, and with that comes dispute resolution mechanisms. So if we can find a platform, if we I want to advocate that we want to, if we are to promote awareness, these platforms can be also a good opportunity to increase our awareness. For example, auditors as well, HR key personals as well. So they will know that there are other alternative dispute resolutions that are more effective and efficient than going to litigation.
Yeah, I completely agree with that on that last point, especially. And I can also relate to the fact that parties do tend to opt for, say, the Singapore Arbitration Center or the Dubai Arbitration Center because it sounds more fancy and it has the international value, I guess. But they almost always ignore the fact that this will increase your cost like tenfold, as opposed to going through a national level arbitration center. Um, Thank you. So, Ms. Lutfi, another question we have in the chat section. What are some of the digital developments made in Maldives when it comes to ADR? So, is there any ODR, like online dispute resolution processes being implemented on, and what about the use of AI, for example, when it comes to ADR?
At the moment, we do not have formally regulated online ADR mechanisms. The only platform we have is MIAC, but most of them it's not pro into online ADR mechanisms to the extent that we discuss online ADR mechanisms.
Okay.
So at the moment, as I mentioned, we are very new. We have to develop our own legal frameworks for online ADR as well.
Sure, no problem. So we have another question from Mr. Amrit Rajapakse, who is a ADR expert in Sri Lanka. So his question is that I'm happy to hear that Maldives is drafting a mediation act. Until the new act is passed, can mediated settlement agreements be entered as arbitral awards and enforced under the Arbitration Act 2013? Is this process ever followed? Thank you.
Sorry, can you repeat the question?
Yeah. So I'm happy to hear that Maldives is drafting a mediation act. Until the new act is passed, can mediated settlement agreements be entered as arbitral awards and enforced under the Arbitration Act 2013? Is this if this process is ever followed?
Thank you. We have recently had a case that was in the middle of arbitration proceedings. The parties actually negotiated and resolved. And if they opt for, they can request the arbitrator if it is in the if the arbitration proceeding has begun, then they can give. But for the time being, mediation agreements are not recognized as judgments or not given legal recognition by the courts.
Okay, thank you. So Ms. Lutfi, last question. What is the best way to build panels with real sector expertise in tourism, fisheries, maritime, and constructions?
So I think these industries are actually well developed, even though our ADR mechanisms are not developed. These sectors, technical level, they are well developed, and we have expertise in all these areas: construction, tourism, and maritime trade as well. So fisheries as well. So when we look into these industries, we already have experts that can be embedded into these panels that can provide expert opinions as well. But in some sectors, for example, maritime trade or fisheries, there might be limited key personnel. But when it comes to tourism and construction, we have quite a few number of experts in those areas. So I think one way is for institutions, for example, to have recognized experts that they would recognize when resolving disputes, like licensed mediators or licensed arbitrators, to have and licensed experts for each group. They can come up with something so that the parties will have confidence in these panels as well, and the parties will also know who are the key players and experts in a specific field as well. So to begin with, I think the institutes, like for now arbitration, for example, MIAC can play a proactive role in coming up with a list of these if the industry people are interested in that. So I think these are the things that can do, and I think these experts will be very interested to be recognized as experts in the field, because we see that we already have list of licensed auditors as well. So it's a privilege as well to be given recognition. So I think we already have that process, and we can do that in that manner to begin with.
Noted, noted. Thank you so much, Ms. Lutfi. I think that's the end of our question and answer session. So I'll just move towards the concluding remarks. Ladies and gentlemen, we have reached the close. I extend my heartfelt gratitude to all our participants and our speaker. Who have contributed immensely to the success of this event. It has been inspiring to see the level of engagement from everyone, and I believe that the insights that we have received today will play a crucial role in shaping the future of ADR, especially with regards to sector-specific improvements in our region. So just before we end this webinar, Ms. Lucy, would you like to say anything in closing? Ms. Lutfi, can you hear me? So yeah, just before we end the webinar, would you like to say anything in closing?
Sorry.
Yeah, I just mentioned that before we end the webinar, would you like to give any closing remarks?
Uh, I think it's actually a very good initiative that SARCO is doing, because today we see here experts from different jurisdictions, and this is the seminars or forums where I have mentioned earlier, where we can exchange knowledge, because from Maldives there are key aspects or experiences where other jurisdictions can um, adapt to our experience as well. And when I attend other forums and when I hear how the other foreign jurisdictions adopt or different mechanisms to resolve their own disputes, we see that most of the time our issues are common. So I think these kind of platforms play a vital role in developing our ADR mechanism. So it's a great initiative. And thank you, SARCO, and thank you for all the participants for listening today. Thank you.
So thank you, everyone. We will be ending the webinar. So thank you for joining, and until next time, take care, everyone.